Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Stephen Sidbury, decided on June 18, 2024. Chief Judge Wilson. Defendant Stephen Sidbury has been evaluated and treated for various mental illnesses since childhood. He has been incarcerated since 2013, first in pretrial detention while awaiting trial for a homicide and related charges, and subsequently upon conviction of those charges. While awaiting trial, Mr. Sidbury was placed in solitary confinement at Rikers Island. In 2014, he set fire to a stack of papers inside the cuffing port of his solitary cell door. He was charged with arson in the second degree, a violent felony offense. Mr. Sidbury was subsequently convicted, after a jury trial, of arson in the second degree and sentenced to 25 years in prison. The appellate division unanimously modified the judgment, in the interest of justice, by reducing the sentence term to 10 years, but otherwise affirmed. On appeal, Mr. Sidbury raises three issues. First, he contends that the trial court erroneously precluded him from presenting psychiatric evidence in his defense. Second, he contends that the evidence was legally insufficient to convict him of arson in the second degree. Third, he contends that his trial counsel was ineffective for requesting a charge on fourth-degree arson instead of fifth. We now reverse and remit for a new trial solely on the preclusion of the psychiatric testimony. Stephen Sidbury first showed symptoms of mental illness when he was in daycare and was first prescribed psychiatric medication at the age of 10, while he was in foster care. His medical records showed that he has attempted suicide and has been psychiatrically hospitalized multiple times, diagnosed with borderline personality disorder, post-traumatic stress disorder, and bipolar disorder. In 2013, when he was 20 years old, Mr. Sidbury was arrested and indicted for murder in Brooklyn. He was incarcerated on Rikers Island following his arrest and remained there for the next several years awaiting trial on that indictment. Over the course of the several years he was held on Rikers Island and elsewhere, Mr. Sidbury was charged with multiple other offenses. One such charge came as a result of Mr. Sidbury setting fire to papers inside the cuffing port of his cell door while in solitary confinement in Rikers Island. A cuffing port, also known as a food box, is a metal box built into each cell door to pass items into the cell or to handcuff an individual inside the cell from the outside of it. The port has two plexiglass lids, one facing outside the cell and one facing inside the cell. The dimension of the cuffing port is 18 by 12 inches. After a corrections officer smelled a burning odor, he walked over to Mr. Sidbury's cell. He saw a fire in Mr. Sidbury's cuffing port, which he reported to another officer, who looked through the plexiglass lid and saw smoking debris and papers but no flames. The officer then concluded that Mr. Sidbury had set fire to some papers inside the port, retrieved a spray can of water, and extinguished the debris. The fire damaged the interior plexiglass lid, which was bubbled and discolored. There were also some burn marks on the metal. He was charged with arson in the second degree, a violent felony offense. Mr. Sidbury was evaluated multiple times for competency to stand trial pursuant to CPL 730.30. The examiners had no access to and thus did not review any records of his mental health treatment prior to his incarceration at Rikers Island, but instead were limited to records created by Rikers Island staff. The staff, believing he was malingering symptoms to control some of the things that happened to him while incarcerated, diagnosed him with antisocial personality disorder and adjustment disorder with mood and conduct disturbances. After 3 years of these evaluations, the examiners concluded that he did not presently have a major mental illness, and he was therefore declared fit to proceed to trial. Throughout this time, Mr. Sidbury was represented by the Legal Aid Society. Following the Section 730.30 competency evaluations, however, Mr. Sidbury's representation within the Legal Aid Society changed. On July 18, 2018, about 45 days after becoming his attorney of record, Mr. Sidbury's new counsel served notice, pursuant to CPL 250.10, of his intent to offer psychiatric evidence in support of the affirmative defense of lack of criminal responsibility by reason of mental disease or defect, and/or, in connection with any other defense, CPL 250.10, 1a, c. The evidence included testimony from Dr. Eric Goldsmith, a board-certified forensic psychiatrist and professor at New York University's School of Medicine, who planned to testify that Mr. Sidbury lacked the capacity to commit arson in the second degree on the date of the cuffing port fire. The trial court rejected Mr. Sidbury's request to accept his late notice of intent to provide a psychiatric defense based on lack of capacity. The court noted that CPL 250.10 provides such notice should be served within 30 days of arraignment and that Mr. Sidbury's notice was more than 1,400 days late. Mr. Sidbury's counsel responded that, at that point, he had only been on the case for 60 days, and the court responded that this was an ongoing and pointless exercise in dilatory tactics as Mr. Sidbury had prior competent counsel and there had been no finding of incompetence. Counsel noted the records and reports the court was relying on regarding competency had been written pursuant to CPL 730.30 rather than 250.10, two separate statutes requiring different psychiatric evaluations directed at different legal issues. Despite recognizing that CPL 250.10 would require admission of the late psychiatric evidence if needed to afford a defendant substantial justice, the court refused to entertain the possible admission of the testimony, stating, "What's missing in this case is your claim is invalid. There's no substantial justice in recognizing this claim. There's no substantial justice related to any claim that your client is incompetent. This is all a history of dilatory tactics. I'm not putting up with it anymore. The case is going to trial now." Mr. Sidbury's counsel asserted that because they were still in the pre-trial stage of this case, with 52 days before the start of jury selection, there was enough time for Mr. Sidbury to be examined by the people's expert without delaying the trial. Counsel also stated that precluding Dr. Goldsmith from testifying would interfere with Mr. Sidbury's constitutional right to present a defense. Counsel reiterated that the legal standard for CPL 250.10 was different from whether Mr. Sidbury was competent to stand trial pursuant to Section 730.30. At that point, the court rejected Mr. Sidbury's application because there was nothing that established a basis for believing that he lacked capacity. You're putting in a claim saying that you're going to speak to a doctor, and maybe he's going to find this. Because of the court's refusal to allow Mr. Sidbury to call Dr. Goldsmith as a witness pursuant to CPL 250.10, Mr. Sidbury's counsel made an application for legal aid to be relieved from representing him, which the court denied. Counsel's supervisor from the Legal Aid Society subsequently made an application in front of the court in response to that denial. She conceded that the untimeliness of the CPL 250.10 notice was a malfeasance by the Legal Aid Society. She acknowledged that because the court was denying Mr. Sidbury his right to present a defense due to counsel's malfeasance, another attorney from a different office might be in a more advantageous position. In response, the court replied, "I take issue with what you're saying that there's a malfeasance. I don't think there's a malfeasance. I think that there was a rational and reasonable decision made by the attorneys in this case is that there was no psychiatric defense. There is no psychiatric issue. There is a malingering issue. There is a wonderful act that he puts on. There is a calculated effort to interrupt and defeat a trial on the one occasion he was found unfit. They sent him back within 30 days. Your client does not possess a psychiatric defense. Your client does not possess a psychiatric issue. He's a pain in the neck, I have to agree. He's annoying. He's obnoxious. He's offensive. He's interrupting. But everything is calculated on his part to impede a trial and to defeat everybody's interest. He is basically a person who has determined that he has nothing to lose, so why not throw it all out there and be as impossible and difficult as you wish. Now, I think that is psychiatric." Counsel's supervisor detailed Mr. Sidbury's psychiatric history and replied that it was not mutually inconsistent to be a pain in the ass, to be manipulative, and to suffer from serious psychiatric problems, to which the court replied, "We fundamentally disagree." It said, "I'm sorry. There has to be a line drawn between the possible existence that he is not completely free of psychiatric issues and the finding that he is, on the basis of his psychiatric issues, so flawed. I appreciate the fact that he may have some issues, but are those issues such as to require a 250.10 notice and a defense based on that kind of circumstance? And I say no because I've observed this defendant for 4 years and his conduct over the last 3 to 4 years. And I say that the kind of conduct that he has demonstrated, both today and every other day that he's appeared here, is calculated conduct. His conduct is always to one objective, and that is to interfere with the trial, to interfere and defeat and impede the proceedings that we have here. He does not manifest these other issues as a person who is, in fact, psychiatrically flawed in other respects. He doesn't, as far as I can tell, satisfy the diagnosis criteria." The court once again denied the request for counsel to be relieved, ruled the CPL 250.10 notice was untimely, and the case proceeded to trial. At the close of testimony, Mr. Sidbury's counsel moved to dismiss the charge of arson in the second degree, arguing instead that the jury should be presented with the lesser included charge of arson in the fifth degree. Counsel argued that the prosecution had not presented evidence that Mr. Sidbury burned a building as required by Penal Law Section 150.15, but that the cuffing port, which was akin to a garbage can, was property of another, consistent with arson in the fifth degree. The court denied the motion and charged the jury as to arson in the second and third degrees. On September 26, 2018, the jury found Mr. Sidbury guilty of arson in the second degree. Despite acknowledging that he had already been sentenced to 40 years incarceration on the Brooklyn manslaughter and weapons possession charges, and that his total sentence would be statutorily capped at 50 years, the court sentenced him to the maximum term of 25 years in prison because it was symbolic, and the court wanted to punish him. Mr. Sidbury appealed, arguing, 1. His conviction was not supported by legally sufficient evidence because the damage was limited to the cuffing port, which was not a building as defined in the statute. 2. The trial court's misapplication of CPL 250.10 deprived him of his right to present a defense and call witnesses under the state and federal constitutions. And 3. His trial counsel was ineffective for failing to request a charge on the lesser-included offense of arson in the fourth degree. The appellate division unanimously modified the judgment, in the interest of justice, by reducing the sentence term to 10 years rather than 25 years, and otherwise affirmed. The court held that the evidence was legally sufficient to support his conviction for second-degree arson, that the preclusion of Dr. Goldsmith's testimony was permissible, and that Mr. Sidbury's ineffective assistance of counsel claim was unreviewable in the absence of a motion under CPL 440.10. Notably, the court reasoned that counsel's CPL 250.10 notice was both grossly untimely and lacking any showing that the proffered psychiatric expert testimony would be relevant to a particular defense with no excuse offered except law office failure. The court determined that because Mr. Sidbury had been represented by the same institutional provider throughout the proceedings and had undergone 2 CPL Article 730 examinations, counsel would have been alerted to potential psychiatric issues, id. At 415. The appellate division further concluded that counsel's notice did not meet the standard set out in People v. Almoner as it did not contain enough information to enable the prosecution and the court to discern the general nature of the alleged psychiatric malady and its relationship to a particular, proffered defense, quoting Almoner. In sum, the court found the result of Mr. Sidbury's 730 examinations, his behavior in the courtroom, and his history of dilatory tactics supported the court's conclusion that defendant was malingering and had no viable psychiatric defense. In the alternative, the court found no error constitutional or otherwise contributed to his verdict. A judge of this court granted Mr. Sidbury leave to appeal. We now reverse and hold that the trial court's application of CPL 250.10 precluding Mr. Sidbury's psychiatric defense was an abuse of discretion. We have been clear that the governing principle animating CPL 250.10 is procedural fairness and orderliness with the intention of eliminating the element of surprise for the prosecution. See Almoner. See also People v. Gonzalez, People v. Diaz, People v. Burke, People v. Siegel, Ronson v. Commissioner of Correction of State of NY. The statute formulates a procedure for defendants to serve notice of their intent to present psychiatric evidence that is prepared and presented manageably and efficiently, such that it allows for proper notification, adversarial examination, and preclusion when appropriate. Almoner. Under the statute, psychiatric evidence is defined as evidence of a mental disease or defect to be offered by the defendant in connection with the defense of lack of criminal responsibility by reason of mental disease or defect, extreme emotional disturbance, or any other defense. CPL 250.10, 1, A, B, C, see also Diaz. Such evidence is not admissible upon a trial unless the defendant serves upon the people and files with the court a written notice of his intention to present psychiatric evidence. CPL 250.10, 2. The statute contemplates that the notice should contain enough information to enable the prosecution and the court to discern the general nature of the alleged psychiatric malady and its relationship to a particular, proffered defense. Almoner. In cases where the defense is not yet able to make a determination as to the viability of a particular psychiatric defense and its psychiatric basis, the statute permits making amendments to the notice and does not prescribe a time within which such amendments must be made. Although the statute provides for service of the notice within 30 days of the defendant's not guilty plea, the court has discretion to permit service of a late notice in the interest of justice and for good cause shown. CPL 250.10, 2. Late notice is permissible at any time prior to the close of evidence including after trial has commenced. The decision to permit late notice is within the discretion of the trial court. See Burke. That discretion, however, is not absolute, Because exclusion of relevant and probative testimony as a sanction for a defendant's failure to comply with a statutory notice requirement implicates a defendant's constitutional right to present witnesses in their own defense. Instead, the trial court must weigh the defendant's constitutional right against the resultant prejudice to the people from the belated notice. The Sixth Amendment to the United States Constitution, applicable to the states under the 14th Amendment, guarantees a criminal defendant the right of compulsory process to call witnesses in their favor. Ronson. While a defendant's right to call witnesses on their behalf is not absolute, a state's interest in restricting who may be called will be scrutinized closely where maximum truth-gathering, rather than arbitrary limitation, is the favored goal. The Supreme Court of the United States has determined that the preclusion of an entire defense for violating a notice statute to be generally inappropriate, where alternative sanctions are likely to be adequate and appropriate in most cases. Michigan v. Lucas, citing Taylor v. Illinois. Recognizing the legitimate state interests that notice requirements serve protecting against surprise, harassment, and undue delay, the Supreme Court has also observed that the severest sanction of preclusion is justified only when the violation amounts to willful misconduct and was designed to obtain a tactical advantage, or where a less severe penalty would perpetuate rather than limit the prejudice to the state and the harm to the adversary process. Lucas. The trial court abused its discretion as a matter of law and impinged Mr. Sidbury's constitutional right to present a defense and call witnesses when it improperly precluded his psychiatric defense under CPL 250.10. To sanction a defendant for failure to comply with the statutory notice requirement, the court must weigh the defendant's constitutional right to a defense against prejudice to the people from late notice. See Burke. See also Almoner. The court did not conduct that balancing. Instead, the court substituted competency examinations, one of which had determined that at a prior point Mr. Sidbury was not competent to stand trial, and its own lay analysis of Mr. Sidbury's mental health to incorrectly and prematurely impose the severest sanction for counsel's violation of the notice statute. Counsel presented written notice that identified the categories of psychiatric evidence set forth in CPL 250.10 he wished to bring. The notice stated that Mr. Sidbury intended to present psychiatric evidence in connection with the affirmative defense of lack of criminal responsibility by reason of mental disease or defect and evidence of mental disease or defect in connection with any other defense pursuant to CPL 250.10. 1. A. C. Attached to the notice was a curriculum vitae for counsel's proposed psychiatric expert, Dr. Eric Goldsmith. On the record, counsel identified Mr. Sidbury's history of mental illness and diagnoses, delineated what the expert's report would indicate, and explained the reason for the delayed notice multiple times to the court. Counsel explained that Dr. Goldsmith had tentatively concluded that Mr. Sidbury was unable to understand the nature and consequences of his actions at the time of the crime and therefore should not be found culpable. When asked on what basis Dr. Goldsmith would reach that conclusion, counsel stated that the expert would need to examine Mr. Sidbury first. Although Dr. Goldsmith had evaluated Mr. Sidbury's competency to stand trial several times since May 2016, because those conclusions were based only on records from Rikers Island staff, rather than on Mr. Sidbury's entire psychiatric history, and because those conclusions concern Mr. Sidbury's competency to stand trial at a given point in time rather than whether he had the requisite mental capacity to commit arson in January of 2014. Counsel stated that Dr. Goldsmith needed a short amount of time to examine Mr. Sidbury and write up a report with his new conclusions. Counsel requested that the court adjourn so that Dr. Goldsmith could do so and suggested that in 2 weeks he could provide further detail, which would still have been nearly a month before the scheduled start of trial. Even if the court believed the written notice should have been more detailed, the remedy should have been a brief adjournment to allow counsel to amend the notice, not the premature preclusion of the defense. As we highlighted in Almoner, in some cases, amending a notice may be warranted, owing to circumstances and developments that vary from case to case, but it is subject to the court's determination as to good cause, timeliness, prejudice, and other appropriate considerations. Here, the trial court considered timeliness, but did not consider prejudice or any other appropriate considerations, before precluding Mr. Sidbury from presenting a defense. Turning to the timeliness of the notice, the trial court's failure to balance prejudice to the people resulting from the delayed notice against Mr. Sidbury's constitutional right to present a defense was an error of law. Although the dissent alleges we misunderstand the CPL 250.10 and Sixth Amendment standards and mandate a showing of prejudice where none is required, the consideration of whether excusing the procedural requirements would prejudice the prosecution, is embedded in New York State decisional law, see for example Almoner, Diaz, Burke, Gonzalez. Indeed, Just as our dissenting colleagues note that CPL 250.10 was enacted to eliminate the element of surprise, citing Almoner, our case law carefully acknowledges that this very rule further protects the people from the prejudice caused by surprise mental health evidence. Gonzalez. Here, the people never asserted that the late notice would prejudice them. Even when defense counsel asserted in open court that the people would suffer no prejudice, the people did not dispute that statement in any way. Although the people now contend that they would have been prejudiced because the long untimeliness of the notice prevented them from examining Mr. Sidbury close in time to the arson, that argument isn't preserved for our review because the people did not state it or make any claim of prejudice in the trial court. See People v. Bauman & Sons Buses Incorporated. The trial court did not consider potential prejudice to the people or alternatives that might cure any prejudice, such as a delay of the trial, a sanction short of preclusion, or a limitation on the scope of Dr. Goldsmith's testimony. The court never once mentioned prejudice in its analysis, relying instead on the length of delay and the court's own conclusion that Mr. Sidbury's malingering demonstrated that he possessed the legally requisite mens rea at the time of the arson. Moreover, Mr. Sidbury's counsel explicitly stated that he would have a more detailed report in 2 weeks, an adjournment period that would still afford the people a month before the start of jury selection. Where there is no prejudice to the people, and where the result of preclusion is to deprive a defendant of due process, a decision to deny such an adjournment must consider whether doing so has the disproportionate effect of punishing a defendant for counsel's dereliction by depriving the defendant of a defense. People v. Hartman. Both our case law and the United States Supreme Court case law emphasize the predominance of the right to a fair trial over purely procedural requirements, especially where no prejudice would result from waiver of a deadline. C. Diaz, Washington v. Texas, Wardes v. Oregon, Chambers v. Mississippi. Beyond failing to consider prejudice, the trial court also did not explicitly consider whether the delay was in good faith. The only cause offered here was law office failure. That representation should be understood, however, in the context of a defendant who was waiting for several years to be tried on several different matters, pending in different courts within New York City, and who was sometimes held in facilities outside of New York City, including one near the Canadian border, and whose fitness to stand trial was fluctuating and uncertain. In any event, the record does not support a finding that the delay was intentional or provided any sort of advantage to Mr. Sidbury. The court based its preclusion of the proffered expert testimony in part on its own diagnosis that Mr. Sidbury was competent in manipulating the system. It reached that conclusion in part by equating two distinct determinations that are not equivalent: whether Mr. Sidbury had the mental capacity to stand trial pursuant to a CPL 730.30 evaluation, and whether Mr. Sidbury had the requisite mens rea to commit the crimes charged pursuant to CPL 250.10. Our dissenting colleagues also erroneously equate the two disparate standards. As the Supreme Court has noted, evaluating a defendant's competency is a present-tense determination, related to a defendant's capacity to understand legal proceedings. See Dusky v. United States. By contrast, the psychiatric evidence Mr. Sidbury intended to present focused on his capacity to form the requisite mens rea at the time of the crime. The court also impermissibly based its decision to preclude Dr. Goldsmith's testimony on its view that the psychiatric defense would have failed. First, the court could not have made any preliminary threshold determination about the defense without, for example, reviewing the expert's report that had not yet been written. Second, the court's view that a psychiatric defense supported by a qualified expert would fail should not figure into the calculus in deciding whether to allow a late notice, especially where prejudice had not been implicated. Absent some other reason to preclude an expert's testimony, for example, lack of qualification as an expert, the severe penalty of precluding Mr. Sidbury's defense on the court's own determination about the viability of the defense is not consistent with the proper considerations of a defendant's Sixth Amendment constitutional right. Accordingly, the trial court's application of CPL 250.10 was an abuse of discretion. Mr. Sidbury argues that the evidence was not legally sufficient to sustain a conviction of arson in the second degree. Under Penal Law Section 150.15, a person is guilty of arson in the second degree when he intentionally damages a building or motor vehicle by starting a fire or causing an explosion. Two concessions by Mr. Sidbury make it impossible for him to prevail on that claim. First, counsel expressly stated that for the purposes of his legal insufficiency claim, Mr. Sidbury was making no argument based on lack of intent. Second, he explained that although the metal cell door should not be deemed to be a building for the purposes of the arson statutes, he could not advance that argument on appeal because Mr. Sidbury's trial counsel had taken the position that the metal door was a building within the meaning of Penal Law Section 150.15. With those two concessions, The argument pressed by Mr. Sidbury on appeal is that the cuffing port is not part of the door. The appellate division found that rather than being a separate container, the cuffing port was a built-in, integral part of the door. That conclusion finds support in the record. The cuffing port is bolted into an iron cell door for the purpose of handcuffing and/or delivering food or other items to incarcerated people in solitary confinement. Because it is a necessary part of the door's functionality, and because Mr. Sidbury's counsel conceded the door to his cell is a building, the evidence that the cuffing port was burned is legally sufficient to sustain his conviction. Because we have granted Mr. Sidbury a new trial, we have no occasion to address his claim that his trial counsel was ineffective for requesting a charge of fourth-degree arson instead of fifth. Accordingly, the order of the appellate division should be reversed, and a new trial ordered. Order reversed and a new trial ordered. Opinion by Chief Judge Wilson. Judges Rivera, Troutman and Halligan concur. Judge Singh's dissents in part and votes to affirm in an opinion, in which Judges Garcia and Canataro concur. Decided June 18, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law